President, I ask that we recognize the sponsor and the chairperson of the committee sponsoring the said measure, Senator Grace Poe.
Senator Grace Poe is recognized as the principal sponsor of the measure.
Mr. President, and to interpolate, I move that we recognize Senator Miriam Defensor Santiago.
For the period of interpellation, Senator Santiago is recognized.
Mr. President, I am not yet recovered from my chronic fatigue syndrome, but I make an exception today in recognition of the importance of this bill, of which I am a staunch supporter, perhaps to the farthest extreme possible. I am strongly in favor of this bill. However, I warn my colleagues and all the fellow advocates that we have in this movement that there are many, perhaps tricky, constitutional issues involved in this bill, and we have to make sure that this bill isn't violated when it leaves the Senate so that it could possibly prevail over those who might file a petition in the Supreme Court to question its constitutionality. For one thing, for example, our bill involves at least two apparently conflicting provisions of the Bill of Rights. The first is Article 3, Section 3, which provides that the privacy of communication and correspondence shall be inviolable except, etc., actually meaning to say except as otherwise provided by law. Compare this provision to the subsequent provision that is more famously known as Section 7. The right of the people to information on matters of public concern shall be recognized. So on the one hand, you have the inviolable privacy of communication, and on the other hand, you have the right of the public to know. We are here this afternoon to finesse these two provisions of the Constitution and as well to delve into other possibly too technical points of law. Thus, I do not want to spring a surprise on our distinguished sponsor, and if she decides to respond to my questions tomorrow, that will be perfectly acceptable to me. But now I will begin. First, I will deal with Section 3. Section 3 of the bill, entitled Definition of Terms. My question is this: do the categories of information listed under the definition of terms adequately and accurately cover the categories of information found under the Constitution, Bill of Rights, Article 3, Section 7, which I have just adverted to? The constitutional right to information covers three categories of information, which are, quote, matters of public concern, unquote, namely, 1, official records, 2, documents and papers pertaining to official acts, transactions, and decisions, and 3, government research data used in formulating policies. This is reiterated in the landmark case 2002 of Chavez v. Public Estates Authority. That is the question. If the honorable sponsor would like me to explain the question further, I can do so. So I shall await your pleasure, Your Honor, if you are willing to yield the floor to me for this purpose.
Yes, it will be a privilege, Your Honor, to have our resident constitutionalist from the Senate shed light on the matter so that we can also polish the law and make it better.
I would have wanted to be adverted to as the resident sex goddess of the Senate, but unfortunately that's beyond my capacities this afternoon. As you can see, I'm already short of breath. Let me explain this question. An understanding of the categories as well as different types of information is essential in distinguishing between the mandatory duty to disclose. It is the duty on the part of the government to make matters clear to the public, and on the other hand, the duty to permit access to information. The duty to disclose on the one hand, and the duty to permit access on the other hand. As explained by the Supreme Court in the recent 2012 case of Ideals versus Pisam, unlike the disclosure of information which is mandatory as provided in the Constitution, the other aspect of the people's right to know requires, quote, a demand or request for one to gain copies of these documents, unquote. The duty to disclose covers only transactions involving public interest, while the duty to allow access has a broader area of information which embraces not only transactions involving public interest, but any matter contained in official communications and public documents of the government agency. So, I repeat the question, is there a need for our provision of the definition of terms to classify maybe in the introductory sections, to classify the categories of information which could be considered, quote, of public concern? Wouldn't that be a legitimate source of inquiry, because the Constitution enumerates these categories of information? That is the question.
Your Honor, I believe that anything that will make it clearer to the public what information should be available, what type of information is allowed under this freedom of information. Anything that will make it clear and clarificatory, I think that we should consider it for the period of amendment.
Thank you, Senator Grace. This is perfectly correct answer. Because then we can do this during the period of amendments. I will therefore, if I see any consent on your part, or even tolerance or acquiescence, I will therefore translate my questions into the form of amendments during the proper period. I'm still on this same subject. My next question is, are the definition under Section 3, particularly those of official record and public records, consistent with the use of such terms under other laws and executive issuances? In other words, I'm asking, have you taken a look at all the other laws and executive issuances of the President executive orders? And do we see a distinction between official records on the one hand and public records?
There are many, the particular laws that were discussed, for example, when it comes to presidential privilege or information that needs to be divulged. We have examined also EO 464, which is a compilation of the many court cases that have brought about the distinction between communication that may be deemed as privileged and the right of the president to withhold from the courts, from Congress, or from the public.
Thank you. Last question on this particular section. Is the definition of, quote, information, unquote, consistent with the Data Privacy Act and other laws? I will explain. There appears to be some confusion between what is information and the manner by which the information is stored. This is given particular significance in Section 5, subtitled Access to Information. This section specifically refers to a record under the control of a government agency, regardless of physical form or format. Also, no distinction is made between information and records kept in a governmental capacity or kept in a proprietary capacity. Governmental capacity means occasions when the government exercises the usual duties of governance, peace and order, regulation of the economy, etc. Proprietary capacity refers to the government when it engages in what otherwise would be a valid function of the private sector, like entrepreneurship or private ownership of a certain public utility. So, shouldn't we, consistent with the Data Privacy Act, draw a distinction between what is information and the manner in which that information is stored? For, among other things, by drawing a distinction or by differentiating when the government acts in a governmental capacity and when it acts in a proprietary capacity. These distinctions are emphasized in law school and are not necessarily part of the everyday vocabulary of the bureaucracy. So, if I have the distinguished sponsor's permission, I shall translate this question into an amendment at the proper period.
We will very much welcome the advice and the suggestions to make sure that our bill is doesn't cause any confusion.
Thank you, Madam. May I please go now to Section 4, which is entitled Coverage. Here is the first question on coverage. Are the terms used to identify the covered government entities accurate and consistent with other laws, specifically the Administrative Code? Has the committee compared the language of the Administrative Code with the language of this bill?
Yes, Your Honor, we took the administrative code in consideration with the language of this particular bill and coverage in Section 4.
Yes, but I have a second question on this topic alone. In the second paragraph of Section 4 of our bill, it appears that private entities that act as public service contractors are covered by our bill.
Yes. Your
However,
Honor.
the constitutional principles on the right to information that I adverted to before refer to information under the control and custody of government.
Yes, Your Honor.
So our bill covers private contractors, but our Constitution refers only to records, etc., which are under the control of the government. And in the same vein, freedom of information in other jurisdictions, that means other states, also refer to information under the control of the state. That is why I ask, why is there coverage of private contractors? Because normally in freedom of information bills across the world, if you take a look, they always refer universally to matters within the control of the government. Let me explain further. The inclusion of private entities under the provision on coverage may run contrary to the principle that Freedom of Information Act applies only to documents and other information within the control of the state. Should not the service provided by private entities that act as public contractors be considered as part of the collection and retention by the government of relevant information? In that way, the public may exercise the right of information against the government. Please allow me to suggest that we should further note that with regard, for example, to mining transactions, the Supreme Court in a prior case has noted that under certain provisions of the Philippine Mining Act, RA number 7942, Section 94, paragraph F, the law requires the DENR, Department of Environment and Natural Resources, to maintain the confidentiality of confidential information supplied by contractors who are parties to mineral agreements or financial and technical assistance agreements. These points underscore the need to explain the reasonable ground for the inclusion in our bill of documents and information from private service contractors, since there are already existing laws that provide this very same, that protect the confidentiality of these very same transactions covered by our present bill.
Yes, Your Honor, this is much appreciated, Your Honor. In fact, having reviewed the FOI bill that we have proposed, we are going to propose during a period of amendment, also incorporating the suggestions that we received from our good senator, our constitutionalist, that to avoid confusion, because information produced and received by the government is the information as defined here in their FOI. So if I understood right, our good senator, what she meant was, how about private service contractors? We cannot, should we be able to compel them to provide information that they have, which is not in the care of the government? So what we are trying to propose is that if a particular private corporation enters into an agreement with the government, that they should provide at the minimum certain information to be able to qualify for that contract. For example, suppliers, costs of certain materials, etc. which is already a standard requirement for them to be able to enter into an agreement with the government, so that in that case we don't have to ask for this material, for this information. It will automatically be provided, Your Honor.
Thank you. I feel very maternal to you, chronologically. So I'm afraid I will have to look within myself for the fire to be ignited,
Mr.
so
President,
that I can explicate on these technical points that I'm bringing up.
Mr. President, I think I like our senator the way she is right now, and I appreciate the maternal vibe that she's getting.
All right. I'll go now to Section 7 on the exceptions to freedom of information. One of the exceptions under our bill appears to be presidential communications. The chief executive enjoys the so-called presidential communications privilege, which permits him to withhold information from Congress, the courts, and ultimately the public. Under our bill, it appears that Congress is limiting the presidential communication privilege through Section 7, letter B. If so, does this not violate the separation of powers? The Constitution, in effect, gives the president, as supported by numerous American jurisprudence, the presidential communications privilege, which permits him to withhold information, but our law, in effect, limits the presidential communications privilege implicitly given to the president by the Constitution. It may be argued that Section 7, letter B, is removing or limiting the presidential communications privilege. It states that, quote, once policy has been formulated and decisions made, minutes and research data may be made available for disclosure, unquote. Under the presidential communications privilege, the president cannot be compelled to reveal facts or deliberative material even after a decision has been made. This is a long-standing principle of constitutional law. So I just want to highlight that Section 7, particularly paragraph B, in effect aims to limit this power already widely accepted. Or I shall explain further. Traditionally, the president enjoys the presidential communications privilege, while other executive officials have the deliberative process privilege. These are highly technical terms. The presidential communications privilege covers communications of the president and those advisors in operational proximity to him on matters that form the core of presidential authority. It protects from disclosure both facts and deliberative materials, for example, advice, opinions, recommendations, etc., and continues even after a decision has been made. On the other hand, the deliberative process privilege covers communications of other executive officials. It protects from disclosure only deliberative material, not facts, and ceases after a decision has been made. The presidential communications privilege is a form of executive privilege and is rooted in the separation of powers. Again, I advert to the unspoken but never questioned, never debated principle of the separation of powers in a tripartite democracy. Then I shall go on to quote from an American case. As you know, we are no longer under America, but because of our colonial heritage, we are allowed to cite American cases which are considered not decisive but only authoritative. So let me cite the case of United States versus Nixon, which was decided before 1995. The American court said, whatever the nature of the privilege of confidentiality of presidential communications, the privilege can be said to derive from the supremacy of each branch within its own assigned area of constitutional duties. Certain powers and privileges flow from the nature of enumerated powers. The protection of the confidentiality of presidential communications has similar constitutional underpinnings. And a little later on, quote, a president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way that many would be unwilling to express except privately. These are the considerations justifying a presumptive privilege for presidential communications. The privilege is fundamental to the operation of government, and I would like to emphasize this, inextricably rooted in the separation of powers under the Constitution. Since the presidential communications privilege is, as the American court noted, quote, rooted in the separation of powers, unquote, it is arguable that Congress cannot remove or limit it without violating the Constitution. So, I will now proceed to my next question. Is the intent of our bill, Section 7, Paragraph B, to remove the deliberative process privilege? Are we removing the deliberative process privilege by this section in our bill? Is that the intent?
Mr. President, no, that is not our intent, and our senator is correct that the chief executive's deliberate process privilege is different and distinct from the presidential communications privilege, and that it is rooted in the separation of powers. We are not removing this power of the president. We are, in fact, enumerating the actual exceptions by which the president can also invoke this presidential privilege. For example, when it comes to national security matters or the frank expression of deliberations. These are protected even in our FOI, but so to allay the concern also of our constitutional expert, if there is any way by which we can clarify and to avoid any misinterpretation that we are taking out this special power of the president rooted in the separation of powers, then we will gladly accept it during the period of amendment.
Thank you for your hospitable attitude. I believe it would be best to make this clear in our bill during the period of amendment, because the rationale for the deliberative process privilege is to prevent premature disclosure of decisions and to preserve the quality of decision making. Executive officials might be less candid with their opinions if it would become public. The deliberative process privilege has its origins in the common law of England and is normally under the power of Congress. However, our own Philippine Supreme Court has recognized the existence of the privilege or something substantially similar to it that is rooted in the Constitution. Thus, in the 2007 case of Chavez v. National Housing Authority, the Supreme Court held that, quote, Article 2, Section 28 compels the state and its agencies to fully disclose, quote, all of its transactions involving public interest, unquote. Thus, the government agencies, without need of demand from anyone, must bring into public view all the steps and negotiations leading to the consummation of the transaction and the contents of the perfected contract. Please allow me now to underline the next citation. Such information must pertain to, quote, definite propositions of the government, unquote, meaning official recommendations or final positions reached on the different matters subject of negotiation. The government agency, however, need not disclose so-called intra-agency or inter-agency recommendations or communications during the stage when common assertions are still in the process of being formulated or are in the exploratory stage, end of quote. So I will strongly return to this point during period of amendment because I believe it will be wiser to maintain the privilege in order to prevent premature disclosure of decisions and to promote the quality of decision making. Still on the same subject, may I please go to Section 7, Paragraph D. Section 7, Paragraph D. This provision exempts drafts of orders, resolutions, decisions, and audit reports from the coverage of the law. My question is there a comprehensive listing of the permanent laws, issuances, or regulations to be affected by Section 7, Paragraph D? That is the question. I will give an example. For example, with regard to drafts of orders, resolutions, decisions, and deliberations of the Supreme Court, in its resolution dated 14 February 2012, the Supreme Court enumerated privileged documents and communications as follows. Bullet. Court deliberations are the deliberations of the members in court sessions on cases and matters pending before the court. Bullet. Court records which are pre-decisional and deliberative in nature, in particular, documents and other communications which are part of or related to the deliberative process, that is, notes, drafts, research papers, internal discussions, internal memoranda, records of internal deliberations, and similar papers. And finally, bullet, records of cases that are still pending for decision are privileged materials that cannot be disclosed except only for pleadings, orders, and resolutions that have been made available by the court to the general public. So again, I return to the question, will the bill in the future contain a comprehensive list of the pertinent laws, issuances, or regulations to be affected by Section 7, Paragraph D, or at least be content with a reference to a comprehensive list?
Mr. President, Section 7D is a substantial reproduction of a provision in the Malacanang version and in almost all bills submitted. The reason for its inclusion in the exceptions is because drafts are actually considered as not filed documents yet. Being mere drafts, the documents have no value other than as working frameworks. Also, we would also like to note that references to drafts may lead to confusion, but if there's any other suggestion also by our good senator, we would gladly accept this.
I will make the proper proposal. Next, referring to Section 7, Paragraph E. Section 7, Paragraph E. This provision exempts information obtained by Congress in an executive session. Does this provision refer to all kinds of information without qualification? Is this provision based on legislative privilege? That is the question. In the same way that there is an executive privilege, do we have in Congress, particularly in the Senate, a legislative privilege?
Mr. President, from my understanding, there are certain discussions done during executive sessions that may not necessarily be in the exceptions as stated, but by the nature of, I guess, the powers also of Congress may be withheld, citing the privilege or the confidentiality of the matter as classified by the members of Congress or the Senate. But it may be challenged eventually if the person seeking information, for example, feels that it doesn't fall under the exception, it is not, it's not about national security or for the interests of the public, or if it is meant to cover up a wrongdoing or an act, a wrongful act, then certainly it can still be challenged.
Thank you. Next question, still on this Section 7. With the passage of our bill, will the instances of privileged information found in other laws or jurisprudence still be valid? For example, there are other exceptions recognized in other laws or by the Supreme Court in decided cases which have not been included in this bill, such as, allow me to enumerate them, bullet, information shared or otherwise provided by a foreign government. We have to accept that pursuant to international law and practice. Bullet, the Internal Revenue Code, Section 270, punishes any officer or employee of the BIR who divulges to any person, except as allowed by law, information regarding the business, income, or estate of any taxpayer, the secrets, operations, style of work, or apparatus of any manufacturer or producer, or confidential information regarding the business of any taxpayer, knowledge of which was acquired by him in the discharge of his official duties. Bullet, the Safeguard Measures Act, RA number 8800, Section 14, prohibits the release to the public of confidential information submitted in evidence to the Tariff Commission. Bullet, the RA number 8504, Philippine AIDS Prevention and Control Act, Section 3, Paragraph N, classifies as confidential the medical records of HIV patients. And last bullet, RA number 8043, Inter-Country Adoption Act, Section 6, Paragraph J, classifies as confidential the records of the adopted child, adopting parents, and natural parents. let me add this as a bullet. RA number 7942, the Philippine Mining Act, Section 94, Paragraph F, requires the Department of Environment and Natural Resources to maintain the confidentiality of confidential information supplied by contractors who are parties to mineral agreements or financial and technical assistance agreements. So, I repeat the question. Should we not include in our bill these exceptions that I have just enumerated, which are recognized in other laws or have been decided by the Supreme Court in
Mr.
certain cases?
Yes, thank you. I would like to thank our good senator for that clarification. Mr. President, in fact, Section I of Section 7I mentions that if information requested is exempted from disclosure by law or by the Constitution, in addition to those provided in this Constitution. So then there is no reason for that information to be made available.
That at least has been made of record. Thank you for your response. Let me go to Section 8, titled Mandatory Disclosure of Information. Section 8 requires the mandatory disclosure of the SALN, Statement of Assets, Liabilities, and Net Worth. Does your committee, Madam, believe that the requirements under the Code of Ethics of Public Officials and Employees are insufficient? I can cite the relevant provision of RA number 6713, but it is pretty long and I'm running out of breath and I'm afraid that our colleagues are running out of patience. So I'll just make a reference to Section 68 of the Code of Ethics from number 1 to 4, and then letter D on prohibited acts. So let me repeat the question. Is it necessary under Section 8 to require the mandatory disclosure of the SALN, since there are already adequate provisions in the Code of Ethics?
Mr. President, I think what this law seeks to do is to institutionalize the procedures also and framework to make access to information more efficient. And I think that it's always been an issue when it comes to governance, if our public officials are indeed transparent in their dealings. And I think one of the best ways that we can keep track of the lifestyle or whatever of a public official is also through his SALN. So in this particular provision that we have, there's an automatic uploading of that information, because now, Mr. President, it is available, but you have to request it, and sometimes it takes longer to be able to obtain the complete picture of the SALN. Usually they'll just give you an amount, but not necessarily the particulars. But I would also like to ask, Mr. President, since we have here already the opportunity to speak with our resident constitutionalist, and her advice would be invaluable.
Thank you. May I put in a special request that honorable sponsor shall inhibit herself from showering me with unmerited compliments, because it keeps me off balance,
Okay.
like in tennis.
If that makes her uncomfortable, Mr. President, that is duly noted. What we set forth here, Mr. President, is that there should be an actual disclosure of the SALN of the President, Vice President, members of the Cabinet, Congress, Supreme Court, Constitutional Commission, and Armed Forces with general or flag rank. And my question, Mr. President, is, would it be necessary also to perhaps include local government, for example, mayors, governors, as those that are required to have their SALNs available for public scrutiny? Because right now they are required by the Civil Service Commission to submit, but to institutionalize it, do you think that, Mr. President, this will cause undue burden, or do you think that it might be an idea we can explore?
Oh yes, definitely. the umbrella of public interest and transparency in good governance is sufficiently wide to cover all public officials. In fact, if you draw a distinction between certain public officials who are under an obligation to file their SAL-N under the requirements imposed by law, and those who are not so obliged, you might be drawing a false distinction which will not be sustained by the Equal Protection Clause of the Constitution. I would go even further than that. Why don't we include at this point of our bill a provision on the mandatory disclosures of the total monthly incomes of all public officials from the highest to the lowest? We can impose that function on the Civil Service Commission. In other words, let us compare by digital means the total remuneration or income, not just the basic standard salary, but all the allowances and other forms of income given by an agency to a certain head and other higher officials of that agency, so that we can compare the president in salary and income, for example, and total income with that of the lowest janitor in Malacanang. Why do we have to keep it a secret on what is the basic salary and other entitlements of a senator in the form of certain allowances, commissions, and specific allowances, or maintenance, operating, and other expenses? What is so special about being a senator? Just because you make laws does not mean that we can distinguish ourselves from the rest of the citizenry. So let's have a column available on the proper website, perhaps of the Civil Service Commission, that bases itself on the principle that total income equals the basic salary plus all the possible allowances and sources of personal income. We should define and make a distinction between public and personal use of the funds, where we consider income as equal to remuneration. Are you in favor of that? Because I will propose it as an amendment. I-publish na natin magkano talaga inuwi natin, even only on a paper basis, because of course they will have to deduct withholding taxes, etc. Magkano talaga on paper ang remuneration ng bawat opisyal, presidente, vice-presidente, senators, cabinet members, justices, judges, the military especially with their confidential funds or intelligence funds, or law enforcement agencies with that nature of funds. Why don't we all classify and publish it, so we don't have to go scurrying around from dark corner to dark corner as if we were rats? Why don't we just expose it all to the public, so that the public, when it is election time, can go to that website and see, so A is running for senator, this is what he will receive, and compare the qualifications of the candidate with what he will be receiving. Why don't we do that? Will the honorable sponsor be amenable
Yes.
to this kind of an amendment?
Mr. President, I'm grateful for that support. In fact, I am glad that our senator was able to shed light also on her opinion regarding the matter and to expound on it, in fact, because I think that salaries, being transparent about it, well, they can probably, the reaction can be twofold. I mean, one side can say, yan lang ba ang kinikita ng senador? Diba? Bakit? Ganyan lang pala kaliit, pero ang lifestyle ay ganito.
Mm-hmm.
So it's better to reconcile it because, of course, some of us have spouses also or family businesses, but it's important that, especially since we are receiving public funds to pay our salaries, then it should be, and then she's right, then our senator is right, that it should be part of the disclosure.
Thank you very, very much. If my physical health allowed me, I would kowtow or bow in front of you, because that is absolutely necessary, in my view, in today's deleterious state of public opinion concerning the incomes of public officials, especially those elected on a national level like senators. Bakit ang yaman-yaman ng mga senador? Ang basic salary lang pala nila is 90,000 pesos a month. My chief of staff receives almost 80,000 pesos a month. Maniwala ka na 10,000 pesos only separates me from my chief of staff? Of course not. That's because I have so many other sources of legitimate income provided by my own agency. So let's let the public in. Let's allow the sunlight to penetrate these dark recesses,
Thank you,
so
Mr.
that
Vice.
people will know how much actually I'm receiving. And during election time, people will know whether a person with the qualifications of a certain candidate deserves to receive that kind of a salary.
Yes, Mr. President.
Thank you.
In fact, just as an aside, I think recently there was a show on television that discussed how much the heads of some government-owned corporations were
Yes.
getting so much more than the president.
Yes.
And it could also arouse some sort of support from the public that perhaps we should start paying based on capacity and responsibility, so
That
that
sounds very much like communism. From each according to his need to each according to his want.
so. But again,
But
that will
anyway, let's
shed
get
light on a
rid
lot
of all
of
these
things.
whispering and innuendos about the income of senators, congressmen, cabinet members, heads of government corporations. Even our Christmas bonuses. Let's call them bonuses instead of additional MOOE. That is mental dishonesty.
So that at least we can pay taxes for it, Mr.
Absolutely.
President.
Aba, matuto nga tayo ng transparency. Puro tayo transparency dito eh. Tatakpan natin palagi kung magkano kinikita natin. When I became a senator, frankly, I was astonished at how much I was receiving. And although I tried to bring it up in public, I was treated with complete silence by my colleagues, except by Senator Juan Flavier, who also shared in these halls his own experience when he was first elected senator. So let's get rid of all the doubts and suspicions, normally very unfair to those who do not go beyond the bounds and stay within the limits. Sabihin na natin magkano talagang tatanggap ng lahat na income sources ng isang senador. Dahil alam naman natin, hindi naman kasya yung ating 90,000 a month eh. At hindi matotoo yun eh. Ay, sosta. Anong klaseng bayan ito kung ganun tayo? Mga leader-leader tayo tapos we conspire among ourselves to keep a deep, dark secret and lambast anybody who hopes to reveal the secret to the general and waiting public. Let me proceed. I'm still on Section 8. Section 8, Paragraph B, deals with the mandatory disclosure of transactions imbued with public interest. In particular, subparagraph 7 to 10 deal with procurements. Question: did these provisions take the requirements on procurement under RA number 9184 or the Government Procurement Reform Act into consideration?
Yes, Mr. President. We checked their website and to make sure that we were able to reconcile our proposals and our provisions here with their regulations.
Thank you, and let me congratulate you for doing just that. Now I proceed with still on Section 8. I will repeat what I said earlier. The Supreme Court previously noted that the Philippine Mining Act, RA number 7942, Section 94, requires the Department of Environment and Natural Resources to maintain the confidentiality of confidential information supplied by contractors who are parties to mineral agreements on financial and technical assistance agreements. Does this exception apply under our present bill?
Yes, Mr. President, anything that has been ruled by the courts or by the Constitution as an exception will not be covered by the Freedom of Information.
All right. I will now go, with your permission, to Section 10, subtitled Protection of Privacy. The basic question is the effect of our bill on the Data Privacy Act, which I hope were taken into consideration in our bill. Let me explain this point. Access to information as provided for by the FOI bill should not be construed as a waiver of the constitutionally guaranteed right to privacy of individuals. I started this interpellation by saying that there are two provisions in the Bill of Rights which are natural adversaries of each other. the constitutionally protected right to privacy, and the equally constitutionally protected freedom of information or freedom, the right to know. With the FOI bill seeking to use the internet and information and communications technology, otherwise known as ICT, as a means of promoting freedom of information, the provisions of the Data Privacy Act of 2012, I humbly submit, must continue to be operative. Making explicit reference to the Data Privacy Act of 2012 strengthens the provisions of the FOI bill, particularly sections 7, 12, 17, 18, and 19. For instance, the provisions of section 7, paragraph F, should also be reconciled with pertinent provisions relating to civil records and the manner by which copies or access to content has been permitted under current legislation and rules. In effect, my point is this: can we please make explicit reference to the Data Privacy Act in this bill so I can make the proper proposal during the period of amendment?
Mr. President, we will do that during the period of amendment. Thank you for the suggestion.
Thank you, too. May I go on to section 12, subtitled Procedure of Access, and section 13, subtitled Access and Processing Fees. The question is this: is the procedure of access under paragraph, is the procedure of access, number one, intended to apply across agencies?
Yes.
Is the procedure of access intended to apply across agencies? And is the procedure of access intended to apply regardless of the nature of the demand or request? For example, demand to disclose, request for access, request for a copy.
Yes, Mr. President.
Also, yes.
Yes. We would
And
like-
3, is the procedure of access intended to apply regardless of the nature of the information sought to be examined or copied? May I please explain? My question, I hope, is relevant because, letter A, there may be access procedures already in place with regard to certain forms of information, and letter B, it may refer to decided cases that offer guidance on the manner by which the right is to be protected or recognized by government. For example, with regard to requests pertaining to official information relevant to ongoing negotiations, the Supreme Court said, and I quote, "The right only affords access to records, documents, and papers, which means the opportunity to inspect and copy them. One who exercises the right must copy the records, documents, and papers at his expense. The exercise of the right is also subject to reasonable regulations to protect the integrity of the public records and to minimize disruption to government operations, like rules specifying when and how to conduct the inspection and copying." The Supreme Court laid down these requirements in the case that I previously cited, Chavez versus Public Estates Authority, decided in 2002. With regard to the public bidding process involving disposition of property, for example, prior to contract consummation, the agency must, without need of demand, disclose to the public the size, location, technical description, and nature of the property being disposed, and the terms and conditions of the dispositions, the parties qualified to bid, the minimum price, and similar information. This must be made available at the start of the disposition process. Information, however, on ongoing evaluation or review of bids or proposals being undertaken by the Bidding or Review Committee is not immediately accessible under the right to information. While the evaluation or review is still ongoing, there are no, quote, official acts, transactions, or decisions, unquote, on the bids or proposals. However, once the committee makes its official recommendation, there arises a, quote, definite proposition, unquote, on the part of the government. From this moment, the public's right to information attaches, and any citizen can access all the non-proprietary information leading to such definite proposition. This is also a case I previously cited, IDEALS, which is an acronym, versus PISAM, also an acronym, decided in 2012. So, in effect, my question is, can we specify in section 12 that although the procedure of access in general is intended to apply across all agencies, regardless of nature of demand or request and regardless of nature of information sought, nonetheless, existing access procedures already in place with regard to certain forms of information and decided cases that offer guidance on the manner by which the right is to be protected by government shall remain valid. Should we not include or add to our section 12 a provision that recognizes what has already been laid down by law for certain agencies and what has already been laid down by the Supreme Court decisions?
Yes, Mr. President. One of the overarching principles in this FOI is the promotion of best practices. This is to encourage also sound, civil, efficient FOI communication, and this is in sections 19. But of course, we are willing to accept the amendment to make sure that we are not disregarding a system that's already been in place that is also efficient to providing information.
Thank you very much. I will go on to section 17, subtitled Keeping of Records. In section 17, paragraph A, which considers the presumption in favor of access, are the information and records created and retained under this section subject to disclosure or access? Is this authority in favor of the requesting party to compel not only disclosure or provision of access, but also the creation of information or records, by which I mean written transcript of minutes where only audio recording was available, for example, by the government agency? I shall explain my own question. In the previous case of Chavez v. Public Estates Authority, the Supreme Court said that, quote, the information that petitioner may access on the renegotiation of the joint venture agreement includes evaluation reports, recommendations, legal and expert opinions, minutes of meetings, terms of reference, and other documents attached to such reports or minutes, all relating to the JVA. And I would like to now underline this part of the decision. However, the right to information does not compel PAA, by which it meant Public Estates Authority, to prepare lists, abstracts, summaries, and the like relating to the renegotiation of the JVA, unquote. So, I repeat the question. Please excuse me because I'm running out of breath. Again, under section 17, paragraph A, are the information and records created under this section subject to disclosure or access? Does it include not only disclosure or provision of access, but also creation of information or records? Section 17,
Yes,
paragraph A.
Although citizens, Mr. President, although citizens are afforded the right to information pursuant thereto, they are entitled to access to official records. The Constitution does not accord them a right to compel custodians of official records to prepare lists, abstracts, summaries, and the like in their desire to acquire information on matters of public concern. And this is mindful to the doctrine laid down in the case of Valmonte versus Belmonte in February of 1989. Hence, pieces of information that are matters of public concern and that are readily available are the subjects of the Freedom of Information Law.
Thank you. But let me move on more quickly to paragraph E, also the same section, concerning the UP Law Center, because I used to be, for virtually 10 years, a professorial lecturer in law at UP. With regard to paragraph E, will the charter of the UP Law Center be amended accordingly? And is the reference to the Law Center not specific to the Office of the National Administrative Register? If reference is to the UP Law Center, is there a study on the capacity of the UP Law Center to further undertake the responsibilities under paragraph E? In other words, do you contemplate creating new positions in UP Law Center or increasing the salaries of existing personnel? That's actually what this boils down to.
Mr. President, this is a valid concern, especially since the UP Law Center maintains the official gazette. But it is also stipulated that the official gazette will have an online arm to it. In this particular case, the National Computer Center, under the DOST, is tasked to help agencies of the government and even the UP Law Center perhaps to have their capacity building in order to be compliant to the requirements of for upkeep of information as required by the Freedom of Information. And certainly I think that the Senate in particular, when the UP comes in for their budget hearing, should be amenable to any increases that they would request. If they need more personnel, or if they need more funding to upgrade their system, so that to avoid for it being obsolete, I think that we should welcome and we should understand that requests for an increase.
So in other words, are we willing to grant further resources to the UP Law Center to finance these additional duties that we're giving to it under this bill?
Yes, Mr. President, I think as my capacity as a senator, I think that if they came in requesting this for their budget, I would certainly grant it, although we don't mention individually an increase of the budgetary requirements of each agency in order for them to comply with the FOI. This will be stated in their own budget requests when they come in for the budget hearings, Mr. President.
Section 18, publication in the official gazette. My question is publication in the online version of the official gazette sufficient for purposes of publication and in lieu of publication in a newspaper of general circulation? I have taken note that Section 18, paragraph A, refers not to all legislative acts and resolutions, but only those that are, quote, important, unquote. So therefore, may have a definition more or less, not necessarily by limits and bounds, but at least some indication of what is the scope of an important act or resolution. Anyway, the first question is publication in the online version of the official gazette now sufficient for purposes of publication? Since, as you know, before a law can take effect, it has to be published.
From my understanding here, then yes, it is considered as compliant once they have published it in the online version of the official gazette. But, Mr. President, our good senators right here pointing out that important resolutions or important laws are a little bit limiting and confusing because it's very discretionary in nature. I think that the capacity, the virtual capacity, let's say of an online website is almost limitless. That we should be able to contain all possible laws that we've passed in Congress.
In other words, if there is a doubt, we should resolve the matter in favor of the importance and publish it when there is doubt. In case of doubt, publish.
Yes,
Thank you.
Mr. President.
Section 19, capacity building, promotion of best practices of appropriate information technology. Madam, it appears to me that the bill relies heavily on internet communication technology in order to actualize the dissemination of accurate information. However, digital information can come in various formats. Have we taken care to include in this bill provisions that will ensure that the information will be presented to the public will be accurate, decipherable, and user-friendly? Let me explain. The principles of FOI will be defeated if the file formats used in the implementation of this act shall be those that prevent or hinder analysis and understanding by the public. You can publish it online, but if you put it in very abstruse or esoteric language, no one will be able to understand it. Some formats hinder analysis and understanding by the public. For example, budget spreadsheets. I can never understand these spreadsheets, which are scanned as pictures and uploaded as PDF files. I think that at best they hinder, and at worst they disallow the public from the analysis of the numeric values of the spreadsheet. Digital information, let us remember, can also be manipulated. Thus, their authenticity must be verifiable. My further comment on this point is that government websites must also provide mechanisms to accept feedback from citizens. By allowing citizens to put their comments on the website, the public is made aware of whether the agency is complying with intent and provisions of FOI. Would you accept proposed amendments during a proper period so that I can incorporate these comments as amendments?
Of course, Mr. President, we would gladly accept that, and it's duly noted also. But also, just a small point here. There's a project now, the government, the DOST, called iGov Philippines, and there are certain efforts, for example, to link up relevant government data centers, have a secured government shared network, provide secured payment system for government transactions, etc. So there's been an effort to have an IT infrastructure, but our good senator is right into mentioning that we should have a user-friendly system. We should continuously update it. A PDF file may be very difficult to access, and we should continuously strive so that any changes in technology and also in the times will be incorporated. So all of the amendments that will enable us to actually be compliant with what is necessary in order for our information to be easily accessed will be gladly welcome, Mr. President.
Thank you. I will rise to the occasion if my physical health allows me. Otherwise, I'll just submit my amendments to Her Honor, the distinguished sponsor, so that you could possibly include it in your committee amendments.
And we will, Mr. President.
Thank you. Finally, Section 20 on the use of plain language. This is very ironic, but I have to raise the question. What is meant by the phrase, quote, plain language, unquote? Surprisingly, there are many definitions of plain language. Literacy and communication scholars supposedly have defined plain language as, bullet, clear, succinct, and designed to ensure that the reader understands as quickly and completely as possible. Bullet, clear and effective communication. Bullet, the idiomatic and grammatical use of language that most effectively presents ideas to the reader. The question really is self-evident. This is what the committee means by plain language, isn't that so? Plain language means that as much as possible, we should avoid obsolete or obsolescent legal language such as hereby, wheretofore, accordingly, theretofore, hereinafter, herein, before, after, that makes the writer or the speaker sound merely pompous but inscrutable. Instead, we should just use certain basic rules such as put the subject before the predicate, use the active voice instead of the passive voice, delete all of these legalese that nobody understands and should not be used anymore. For me, the most important information on plain language is found in a little booklet, not even a book. It's called Elements of Style by Strunk and White. And it's very, very cheap. It used to cost only 50 pesos at a certain well-known bookstore, and possibly might cost only less than 100 pesos today. So that is what I mean by plain language. Thank you very much, Your Honor, for your graciousness and your elegance in answering my questions, and I hope that I will be allowed to make the corresponding amendments during amendment period. Thank you.
Thank you, Mr. President. I am glad for this opportunity to having had this privilege to be interpellated and to have learned also from our well-respected and admired senator, especially since we need to make sure that she has her stamp on this Freedom of Information bill, so that we won't have any doubts as to whether everybody had actually their opportunity to field in their questions. So now, I think that hopefully we will also encourage our other senators to put forth their questions so that before the end of this first quarter,